professional dreamers. Jennifer Warren here, back behind the black and blue mic, and reminding you that we are all professional dreamers. Either that or we're fascists. So stick with me for a bit and we'll get into it. I got an email today, somebody asking me to do a show on corruption. So I thought, what the hell? I don't have anything better to do. Let's talk about corruption. You want to talk about corruption? I'll talk about corruption. I'm not afraid to talk about anything. As most people know me will tell you. Anyway, corruption. How did it get started? Well, I have no flipping idea. What I do know is how it works here in America. The way it works in America is this. If you got enough money, then you have a voice. And if you don't have money, then you're just screwed. Because, you see, back in the 1880s, a guy named J.C. Bancroft Davis, let's call him J.C., he was a lying sack of shit who went to the United States Supreme Court on the case of Santa Clara versus the Southern Pacific Railroad Company. Now, that was owned by a robber baron named Leland Stanford. Anyway, in 1881, California lawmakers imposed a tax on railroad property. And Southern Pacific sued. And they made the claim that the law was an act of unconstitutional discrimination under the 14th Amendment. Now, the 14th Amendment, for those of you who don't know, was a law that was passed after the Civil War to protect the rights of freed slaves. And the amendment guarantees that every person has the equal protection of the law. Sounds fair, right? Well, Stanford argued that, Stanford Railroad argued that it was a person too. Because they said the Constitution prohibited discrimination against for racial identity, but it also barred discrimination against the Southern Pacific Railroad on the basis of its corporate identity. Now, the head lawyer, can you believe this bullshit? The head lawyer was a guy named Roscoe Conkling. Now, he was a leader for the Republican Party for more than a decade. And he had even been nominated to the United States Supreme Court twice. Both times he said, no, thank you. And the second time he did it was after the Senate had confirmed him for the United States Supreme Court. And he remains, to this day, the last person to ever turn down a Supreme Court seat after winning confirmation. Everybody else says, great, I got the chair. And he just said, screw you. Well, he was seen by the United States Supreme Court justices as a really honest person who would never lie. Well, he did. When he went to the court on Southern Pacific's behalf, he came back with an astonishing story. In the 1860s, he said that while he was a young congressman, he had served on the drafting committee for writing the 14th Amendment. Now, whether or not he does, I don't know. It doesn't make any difference. But since he was the last committee member still alive, he told the justices that the drafters had changed the wording of the amendment, replacing the word citizens with persons in order to cover corporations too. And laws referring to persons, he said, have, and this is a direct quote, have by long and constant acceptance been held to embrace artificial persons as well as natural persons. That's a direct quote unquote. So basically he was saying that the 14th Amendment, which was passed in the 1880s, long before the first idea of an artificially intelligent computer was even suggested by Turing, he was saying that the 14th Amendment was passed to cover artificially intelligent computers, even though nobody knew what an artificially intelligent computer was. Yeah, right. Okay. Uh, I don't know how you do that, but he claimed that he had this old journal that he said was previously unpublished, never before seen by anyone else. Yeah, see, and it has an unpublished record of the deliberations of the drafting committee. Well, years later, historians would find out that the journal was real, but his story was bullshit. And the journal was, in fact, a record of the Congressional Committee's deliberations, but when you look at it very closely, you find that it has no evidence that the drafters ever intended to protect corporations. As a matter of fact, it showed that the language of the Equal Protection Clause was never changed from citizen to person. But maybe we need to change it from persons to citizen, because that would put an end to this bullshit once and for all. One word changed in the 14th Amendment, where it says all persons, it should say all citizens. And if you did that, Citizens United would fall flat on its face because it would no longer have the legal foundation to stand up. Every law that had been passed to give preferential treatment to corporations would vanish overnight. And as far as anybody can tell, the whole idea of corporations weren't even raised in public debates over the ratification of the 14th Amendment by anybody. Not in any of the states or the states ratifying convention. Never happened. So prior to his appearance on behalf of Southern Pacific, nobody in the drafting committee had ever suggested that corporations were covered. But because he lied his ass off, and because the Supreme Court trusted him so much, they believed him. And because of that, well, today, corporations have the same rights as people. They have the right to fire you if you worship the wrong God. They have the right to tell you that you will be fired or whatever. They have the right to determine whether or not they will deal with unions or deny the right of individuals to negotiate with them in any way, shape, or form. They have the right to tell you how to live. They can tell you, for example, and I've been told this by the Nintendo of America Corporation that I worked for some years ago, that if I were to show my pay stub to any other worker, that I would be fired, even if I was doing it on my own time, in my own home, on days when I wasn't even working there. So that's basically saying, later on, I found out that the reason that they were willing to fire and did fire a lot of women and a lot of guys was simply because it was starting to come out that the corporation was paying women less than men in a state where they can't legally do that shit. And paying women half of what they were paying men for the same work. And that's not right. I don't give a shit who you are. That shit ain't right. Well, years later, after this court case, another case, another case came up raising the exact same question. And this team had the exact same set of lawyers for the exact same company, Southern Pacific. And Southern Pacific's lawyers didn't mention anything about his drafting history or his journal or anything like that. And let's face it, if those lawyers had actually believed him, it would have been malpractice to leave that out. But it wasn't malpractice because they didn't believe him. They knew that it was bullshit. United States Supreme Court had been about to pass judgment, and Southern Pacific cut a deal with California. So that never got there. But their other case did. And when the court issued its decision in this second case, the justices expressly declined to decide if corporations were people. They intentionally refuse to make that decision. All right? Now, that's an important point. Now, Stephen J. Field castigated his colleagues for not addressing what he called the important constitutional questions involved. Well, they are important constitutional questions, but the fact is that corporations are not people. A corporation, for those of you who don't know, is a bunch of legal papers that sits in a box. I know, I've got one. And anybody can get one. I mean, you get a couple of bucks together, you can form a corporation. And that box cannot be put on trial for murder or for abusing people because, let's face it, it's a box. How is it going to respond? Well, a box, paperwork, you're charged with such and such. What do you have to say for yourself? Speak up, can't hear you. Well, that shit doesn't fly. And so corporations can't really be held accountable under law. And because of that, they cannot be considered persons. But in America, they are. No other country in the world allows corporations that much power. Well, let's see. Field, who, like I said, he didn't like the idea that corporations weren't going to be given that right away. So he got pissed off, and he started carrying a gun. And eventually, he became the only sitting justice of the United States Supreme Court to be arrested. And the charge was murder. He was innocent, but, he was still guilty of some pretty serious ethical violations in the Southern Pacific cases, at least by modern standards. He was a personal friend of Southern Pacific, the head of Southern Pacific, and he advised the companies on which lawyers to hire for that set of cases. And he should probably have recused himself from those cases, but he refused to. And even worse, while the first case was pending, he covertly shared internal memorandum of the justices with Southern Pacific's legal team. Now, that's illegal as hell, even by modern-day standards, which are pretty frickin' loose. Now, the rules of judicial ethics really weren't all that well developed in the Gilded Age, so Field he was scared to death of socialism because the idea that people might have money to take care of grandma or health care, he thought that would lead to complete anarchy. Believe it or not, a lot of Republicans still believe that same shit. And so he didn't hesitate to jump in and speak his mind. He said that taxing the property of railroads differently, he said, was like allowing deductions for property owned by white men or old men and not deducted if owned by black men or young men. Well, that's bullshit because, like I said, a corporation is a box of frickin' papers. So, anyway, the Supreme Court eventually made their decisions, and the reporter afterwards writes up a summary. Now, the reporter in the case was a guy named J.C. Bancroft. Now, here's where it gets fun. You see, I'm sorry, J.C. Bancroft Davis. Now, where it gets fun is that he just rewrote history and claimed that the United States Supreme Court had ruled that corporations are persons within the 14th Amendment. Well, excuse me, they never said that. But Field jumped on it, and a few years later, he wrote, Field copied it, what this guy had said, this lie that had been told by J.C. Bancroft Davis,